Up to speed on the latest developments in the case against former Senate Majority Leader Joe Bruno. As you will recall, Bruno was found guilty of violating the Honest Services Law in 2009, and he was sentenced to 2 years in prison. However, he remained free, pending a decision by the U.S. Supreme Court on the constitutionality of the Honest Services statute. Then the following year, a decision was handed down that dramatically narrowed that statute, making it unlikely, it seemed, that the former Republican political heavyweight would serve any time at all. Earlier today, the prosecution in the case against Bruno filed a brief explaining why they believe he should be retried. My next guest has kept a very close watch on this case from the beginning. Paul DerOhannesian is our legal expert. He is here frequently. He's a partner at the Albany-based firm, DerOhannesian and DerOhannesian, and he is joining us now to explain what all of this means. As far as I can tell, bad news for Joe Bruno.
Well, first of all, we never knew what the government's thinking was. But it's very clear that they intend and want to retry Senator Bruno, not only on the 2 counts that he was convicted of, but also on another count involving Leonard Fassler, about $400,000 involved in that count. So I think that's very surprising in a way that we see them wanting to do that, and if necessary, bring a superseding indictment, in other words, a new indictment. There's a reference to that. It doesn't say that there'll be new charges, other than they want to beef up the language supporting their theory.
So what this does essentially, if in fact they win at this level and they are able to file a superseding indictment, it's the reset button that gets hit. And
Correct.
You're talking about going back to the beginning and Joe Bruno having to defend himself all over again, and it's quite expensive and it's quite prolonged, and it seems like a waiting game.
Well, the clock is certainly significant here. If you think about this appeal, it may not be heard until June at the earliest, maybe the fall. Then you need time for a decision. You may not have a decision this year. And if they file a superseding indictment, that once again, as you said, would hit the reset button. It could be a while before you get a trial of that matter.
And he's not a young man, so that's why this is extra significant.
That's correct.
To a certain degree. What do you think they're about here? What are they aiming for?
Well, I think what they want to do is show that they had a sufficient basis to bring this charge, not only on the theory that was discredited by the Supreme Court, which involved the concealment of his financial interests and activities, but they go to great lengths in this brief to point out the facts that support a quid pro quo theory, that the senator solicited funds from Abrazzese and took official actions to benefit him. And I think that's what's important here. They lay out here why there's sufficient evidence under a theory that is valid, basically a quid pro quo, suggesting, in fact, sufficient evidence of a kickback.
And that was actually the piece of honest services that the U.S. Supreme Court left intact. When we say it narrowed the statute significantly,
That's right.
They said this particular thing you still can go forward on. And actually, that is exactly what they're doing.
And that's exactly what we see in the Senator Kruger's case. He's charged with honest services under the same theory.
And also, interestingly, you pointed out to me before we went on that there are some people in there that are familiar, who are footnoted in the file.
For example, Anthony Seminario's case gets cited in this brief once again for some of the theories that the government is supporting. And if you look at the brief, it's interesting. Some of it is like a who's who of New York politicians, unfortunately, whose cases have been litigated that have developed some of the theories here.
And Anthony Seminario, of course, a former Queens assemblyman who was, in fact, convicted, went away, and died in prison.
Correct.
So it's actually a pretty sad situation. Also, I mean, you bring up Kruger, it reminds us again of the litany of people who have gone down to corruption charges, or at the very least are facing them. And this case is not going away anytime soon.
That's correct, and I think you see that is the atmosphere and tenor of the U.S. Attorney's Office in both the Northern District and Southern District, and I think that's been very clear. And I think the message here is they do treat this case very seriously. They are not abandoning it. They are not giving it up. It's clear a lot of energy and effort went into this brief to make a case for why the senator should be re-prosecuted.
Now, just to be clear, he can fight this, correct?
Absolutely. And again, they're going to get a chance to reply to this brief, and then there's going to be an argument. So a Circuit Court of Appeals has to permit the government to go forward.
Paul DerOhannesian, thank you very much. You will be back because now we have breathed new life into this whole situation. Thanks very much.
Thank you.